I think let's move on first of all by introducing myself and my colleague Joe Kilbreck. My name's Alistair Matheson. I'm a partner at Brokerage, and I am part of the professional indemnity team, which is part of the wider insurance and risk unit at Brokerage. I've spent nearly the last 20 years focusing on professional indemnity claims, dealing with claims against lawyers, architects, engineers, and indeed insurance brokers, among others. Jo Kilbreck is an associate in the same team, and likewise her practice is focused on professional indemnity claims of all natures. Now, let's move on to the start of our talk and to tell you a little bit more about it. First of all, this is not an exhaustive survey. We have a 3-volume loose leaf professional negligence encyclopedia that sits where we do in the office, although I've not seen it for a while. And at this point, normally I pick up the chapter on insurance brokers, which is currently 147 pages long. Obviously, I've not been to the office like many of you for some time, so I can't even virtually wave this in front of you. But it would certainly give you a good idea that I can't, or we can't hope to cover everything. So what we've tried to do is pick and choose some of the topics and some of the duties which will hopefully provide you a framework to allow you to examine your practice and how that can be improved, and any areas that perhaps need a little bit of work. The first thing we're going to talk about is brokerage duties. What are their sources? Where do they come from? And we'll take a look at some of the most standout duties there, perhaps some that you'll be aware of, but maybe some that might be a bit of a surprise. Then we'll take a look at some situations that most brokers will come across and try and apply them in practice. So we'll look at policy inception, which from a broker's perspective is absolutely key. What obligations do you have for gathering information from the insured? And almost as importantly, if not more so, what knowledge do you need to impart on them so that they understand the policies they're getting and the limits and indeed obligations that they have in relation to that? Doesn't stop there, because there are a number of post-inception tasks that a broker is responsible for. And we're not just talking about midterm adjustments. We could be talking about holding documents and explaining the policies that have been obtained. Then we'll have a look at what your responsibilities are when claims come in. How should you act? And let's face it, they will inevitably come in, and that's what insurance policies are for. We'll also look a bit about just after that, the consequences of not following that, but also then applying it to business interruption policies, which obviously are very much in the public eye just now. We'll consider some of the issues that could be arising, and hopefully and possibly give you some comfort. So I'll pass over to Joe, who's going to tell you oh, sorry. One more slide from me. My apologies. It's not a seamless transfer over. So broker's duties, what are the sources of them? First of all, you've got terms of business. Why are they important? Very broadly speaking, they define the scope of what you're doing and identify who you're advising. They might provide possible limitation clause. And I think it's important to remember that you do need to have regard to these documents. They set out what you're holding yourself out as doing. It's not just a tick box exercise that you send out a letter or the pro forma document. Implied duties. These are, in very broad terms, things courts have found brokers are obliged to do. And once again, I would normally take out the 3 centimetre thick section on insurance brokers' duties to show you, just to enforce how many of them there are. These can also be relied on by some third parties, depending on your relationship with your primary insured and what you've set out to do. Many of these duties are simply common sense, as I think I've said before. Others can be quite surprising. You've got statutory duties as well. Compared to the implied duties, these are relatively small in number, and we're not going to dwell on them just for reasons of time. You do also have GDPR obligations, and there's the overall obligation to perform with reasonable skill and care, set out in the Supply of Goods and Services Act 1982. ICOBs and broader FCA guidance also provide a framework against which brokers have to operate. And we'll have a look at some of the standout obligations that are imposed by them. And as I've said, we'll have a look at the consequences if these duties and obligations are not followed. And now, this time, I absolutely mean it, that I'm going to hand over to Jo. This is the next slide.
Okay, so I thought I'll start by expanding on some of the points that Alistair had mentioned regarding terms of business. As Alistair said, this isn't a tick box exercise, and the importance of issuing terms of business is often overlooked. But it's a really useful part of a broker's armour should queries about your service arise later down the line. It's also in line with ICOB's aim of ensuring customers are treated fairly. So why are they important? Well, they set out the contractual relationship between the broker and the client so that parties know what to expect from one another. So it's a really useful tool for managing expectations from the very beginning. Good terms of business will be clear and concise, record the business relationship, how data will be processed, any regulatory framework which the parties need to operate within, including, for instance, whether the customer has the right to complain to the FOS, for example. Of particular importance is defining how you hold client money and how you would be paid. So they are very important. And my experience, and I'm sure this will be Alistair's experience as well, is that in times of uncertainty or economic downturn, which we may be in at the moment, it's quite common that you see a spike in claims and complaints against professionals. And one of the first things that a professional would do in that situation should be, other than notifying their insurer, of course, would be to consult their terms of business and determine whether the grounds of the complaint or the claim is something which has already been addressed within that. So, being able to point your customer to a really comprehensive set of terms of business can really help address any issues that arise early on. And without having written terms of business, the scope of the contract between a broker and a client is much more open for interpretation. I've said that you should ensure that you identify your client, which might sound obvious, but you just need to be clear who you are acting for. The default position is that you would be acting as agent for the insured, but if there's an occasion where this would be different, then you must ensure that that's reflected in your terms of business. It's also important to set out the scope of the services that you're going to provide. It can ensure a streamlined contracting process. It avoids any ambiguity in the services that you're going to provide, particularly, if you were providing ancillary services with an additional fee. If that was an option, you might want to make sure that's in your terms of business, because it can avoid any confusion later down the line. And in line with the Insurance Act 2015, I'd recommend that you ensure your terms of business define what the broker's role is in compiling risk information and highlight the need for the client pre-contractually to disclose relevant information, and also what the consequences of not meeting that. I've also suggested that a terms of business letter might incorporate limitation of liability. And clauses such as that, they're designed to restrict the loss which the broker might be responsible for, or set a cap at which they're not liable for anything above X amount. It's quite sensible to do because it can ensure that your liability is proportionate to the level of client engagement. There's lots of law surrounding these type of clauses, and it's not for today's session, but I think the important thing to bear in mind is that the clauses are at risk of being challenged unless they're fair and reasonable, so it's important to bear that in mind. Moving on to my next slide. On implied duties. As professionals, we're all expected to adhere to a set of standards, and if we fall below those standards, then we can be liable for the loss or damage which flows from that breach of duty. As Alistair mentioned briefly, duties can be owed in delict, tort, and contract as well, and even where there isn't a written contract, duties can be implied. In fact, over recent years, actually, we've seen quite a high standard being set for brokers. And indeed, the situation of late may have led to some brokers having to advise their customers that cover is not what they expected. And these can be difficult conversations to have. And it could leave a broker questioning whether the advice tendered at policy inception was lacking in any way, or are they in the firing line? So I've put in bullet points just a few of the key duties that would have a significant bearing in these type of situations. I've started with quite a key one, and that's make sure that you record the fair presentation of risk. The duty to enclose material and the duty to disclose material information has been enshrined in the Insurance Act 2015, and it can be quite onerous on a broker. To discharge the duty, you'd need to take all reasonable steps to elicit that information from the client and to actively make sure that the client disclosure, and importantly the consequences of failing to disclose. And it's down to the broker to satisfy themselves that their client understands that duty. This is, a critical factor when pre-inception of the policy, so I'll come on to talk about that later on in the session. I'll also come on to talk later on my next bullet point, which is to advise on the scope of the insurance to be obtained. And that's obviously you're advising as a broker on the whole process of obtaining coverage, and you could be liable for significant losses should that cover be inadequate or insufficient. So it's vital that you know your client's needs to ensure that you're assisting them to obtain appropriate cover. Unnecessary risk of litigation is also a key duty to be aware of. A broker has a duty to obtain cover that meets their client's needs and not to expose the client to unnecessary risks, and that includes the risk of litigation. It's particularly manifest where the broker has been responsible for drafting or perhaps agreeing wording which doesn't maybe result in the cover that the client was expecting. And if that cover is found to be unclear, perhaps if there's a term that's ambiguous or leaves room for debate, then that could expose the client to unnecessary risk of litigation, which could in turn mean that the broker could be held to have been in breach of their duty. Thankfully, I guess, in recent case law, it tends to suggest that brokers aren't quite as easy a fallback target if a client hasn't been successful in pursuing an insured. Even where breach of duty has been, I don't sound very doom and gloom, but the positive that even where breach of duty has been established, if that wasn't the cause of the loss, then the broker will not necessarily be liable for those losses, and that's what we would call a break in the chain of causation, and that has been recognised in some recent cases, so that is a positive and no doubt welcomed by brokers. I've also suggested that you'd wish to retain documentation to enable a claim to be made. Both Alistair and I will touch on that later, so I'll not say too much about it now. And I'll also come on to explain a bit more about continuing duties, because they don't end when the policy is in place. And I'll, as I say, I'll touch on that later. And I'll hand you back to Alistair now.
Okay, thank you, Joe. That was much more smoothly done than I did to you. We have our first question as well, which is very exciting. Normally, both Joe and I like taking questions when you're there in person, and it breaks up the me speaking or Joe speaking constantly. The question is, what are the main differences you tend to see between terms of engagement for solicitors and brokers? And, well, possibly we're the wrong people to ask, because very often we get instructed when it is a problematic file, let's say, and that's usually the one where perhaps there's been a lack of attention to it, and that means that there's perhaps not been a terms of business letter sent out by either a solicitor or an insurance broker. I think that rather than there being more commonality among solicitors or among insurance brokers, I think it's fair to say that in our experience, what they share in common is a wide variety, from nothing to 5, 6, 7, 8 page letters that you would be the gold standard. You'll both find solicitors doing anywhere on that continuum, and you'll find brokers doing it anywhere on that continuum. Something is generally better than nothing, is what I would say there. And in particular, if you have got you've made the effort to get a standard set of terms of business drawn up, it makes complete sense to use it when you can, because it really sets the foundation for the ongoing relationship. I should also just to talk about the questions there for a minute, in that you can't just put your hand up and interrupt. Please feel free to use the question and answer function, and while you think of a question, put it down rather than waiting for it at the end, because we can obviously see them as a list to deal with either at the end or as we're going through it.
Sorry to interrupt.
No, no.
I was actually going to say that question perhaps highlights as well the importance not to forget that you just prepare, a letter setting out your terms of business, and that's it, and keep wheeling it out. It is important to reflect on these documents regularly and make sure that they're still appropriate for whatever business that you're engaging in, and it's not necessarily one size fits all.
Yeah. Okay, so on to ICOBs and FCA guidance. I'm not going to quote them at length. They are, as you can imagine, quite lengthy, and it's fair to say that it's a good idea to go on the FCA website and have a read of them, because there will be a fair amount there that is completely in the forefront of your knowledge, but there'll be some that might be surprising and might actually make you take a step back and think, is what we do in compliance with that? And that's important for a number of issues. Firstly, if there's going to be a broker's firm, how does someone who's proving that there's been a breach of duty? I don't know what brokers' best practice is. I don't know what lawyers' best practice is in certain areas of law that I'm not familiar with. So the ways with an expert witness, and that's another broken. This has been done inadequately. One of the things that any expert will have regard to is industry guidance, industry regulatory pronouncements, and so on. Now, while a breach of the ICOBs, a particular provision of the ICOB's guidance or rules doesn't necessarily mean that it is directly responsible for someone's loss. It does create a tone, shall we say, if there have been other breaches. It suggests that, consistent with that, there may have been a breach of the duty that's actually been complained of. If, for example, the terms of business letter hasn't been sent out, it suggests that there's a less than rigorous approach being taken to a particular piece of business, even if that lack of a terms of business letter being sent out is nothing to do with whether or not a piece of advice has been provided. So it can be used, they can be quoted back at you in civil claims and disputes, but also can ultimately lead to regulatory issues, as I'm sure we're all aware, with the FCA potentially coming after a firm or indeed an individual who doesn't follow them. So on the slide are just some of the ones that stand out to me as perhaps of most interest. Just in my personal view, it may be that in practice, others are more important to some amongst you. So looking first of all at the client categorization obligation in Rule 2, a firm must act honestly, fairly and professionally in accordance with the best interests of its customer. Now that sets out the background to follow. It sets the scene for the relationship and makes it clear that unless there's some other express agreement, the broker is the agent of the insured, and therefore you must be clear that you're acting in their interest and not someone else's. 5, identifying client needs and advising. A firm must specify, on the basis of information obtained from the customer, the demands and needs of that customer. And I have to say, that's not something I envy of brokers, because it certainly goes beyond that which you generally find imposed on other professionals. If you're going to comply with that, then it's not sufficient to simply provide reasonable advice. Instead, it expressly states you need to go forward in a positive manner to interrogate your client, who may not appreciate the importance of a particular piece of information or a particular policy term. You need to interrogate your client to find out what it is that they actually need. You've got to find out what their own requirements must be, rather than simply following instructions. The third one there, product information, ensure that a customer is given appropriate information about a policy in good time and in a comprehensible form. You can't just let them have a pro forma. You need to actively consider who your insured is and what information is appropriate to them, and also the form and how you express that. So it's no good going to a small business, for example, and giving them a complicated legal treatise. You need to interpret it for them. The FCA guidance provided is also softer than those rules, but the FCA certainly will assume they're followed, and for the reasons I highlighted at the beginning of this slide, it will be important to show that you have at least considered them or complied with them, acted in general accordance with that guidance, because if you don't, it won't necessarily mean you've been in breach of duty, but it does make it easier to set out that case. For those dealing with consumers, and I appreciate that that will not be relevant to many people on this call, this includes an option in outcome 5 that consumers are provided with products that perform as the firms have led them to expect. So that puts the onus on you not just to provide information to them, an explanation of it, but effectively puts you on notice that you are in some way having to construe the insurance policies and not become the insurer, but certainly take on board more than just providing reasonable advice about it, but actually you're saying the policy will do X. The FCA issues guidance on a regular basis. If you look at the news page, the most recent I've come across is obviously quite apt just now, the product value and coronavirus guidance for insurance firms, which is out last week, which I'm presuming all of you have read, and it sets out what the FCA considers firms should be doing to identify any material issues that affect the value of insurance. Now, this is primarily aimed at insurers, but it's possible that brokers will need to take cognizance of it when going forward and advising their insureds. And moving now on to the next slide. Thank you. Look, no hands. I didn't do that. The consequences of failing to follow the duties that are incumbent upon you. Now, the first thing I would say here is the Financial Ombudsman Service. In my experience, given the ease with which, first of all, consumers previously could make complaints to the Financial Ombudsman Service, I'm actually surprised that it's not used more often in professional negligence cases, to be honest. And that's perhaps because claim is a difficult thing to put together properly, but also perhaps a lack of knowledge. Now, it used to be primarily consumers who could apply to the Financial Ombudsman Service, but in the last year or so, that has been radically increased. And now micro-enterprises and small businesses can also make claims to the Financial Ombudsman Service. A micro-enterprise is a EU law term, which is still relevant for now anyway, and that's a business with a turnover or a balance sheet of less than €2 million and fewer than 10 employees. But perhaps of more interest is that a small business in this context is a business with a turnover of less than £6.5 million a year and a balance sheet of less than £5 million or fewer than 50 employees. Now, I'll let that sink in for a little bit if you're not already aware of it. That's actually quite a large business, and especially in the context of the Scottish economy, that includes probably quite a few or quite a decent proportion of the clients of an average insurance brokerage. It also includes charities and trusts. What's also important to bear in mind is that the financial limits for compensation have radically increased as well. Now, up to the 1st of April 2019, it was £150,000, which is still a reasonable sum of money, but could be inadequate to compensate someone for a fairly standard run-of-the-mill insurance claim. Now, that increased to £160,000 after the 1st of April 2019 for acts of remissions before the 1st of April last year. But then for complaints about acts of remissions from 1st April last year to 31st March this year, it suddenly leapt to £350,000, which is obviously more than doubling it. And then from 1st April this year onwards, it's £355,000. Now, that's a significant increase, which suddenly becomes a much greater threat to brokers, because it means that claims that would otherwise have had to go straight to litigation can now go to the Financial Ombudsman Service. Now, I very much hope no one on this webinar has had the misfortune of being involved in a claim being made against the Financial Ombudsman Service, but it's quite a simple process. The customer complains to the firm in question. The firm in question engages in correspondence and then ultimately issues a final response. And then within 6 months of that final response, the customer then makes a complaint to the Financial Ombudsman Service. Now, there are no rules about what evidence can be provided. There are no limits on the kind of things that in particular a consumer can put forward. And they can be wide-ranging complaints, indeed not necessarily focused on actually something that a broker has necessarily done wrong. And the Financial Ombudsman Service will then act as investigator, judge, jury, and in certain cases executioner as well, with very little comeback for the firm that's being complained about if compensation, and as we've seen, this can be quite a large award, if compensation is in fact awarded. And it's not just the possibility of significant financial hit, it's also the potential for a reputational hit if it goes to the Financial Ombudsman Service and then there's a finding against you. The next option is litigation, which the Financial Ombudsman Service was introduced because litigation was thought of as being expensive and time-consuming. Indeed, I think I paraphrased Jeremy Bentham, the humanist, the utilitarianist philosopher, who said that there are three things attendant on all litigation: delay, worry, and expense, and chief of those is expense. That's a 19th century view of litigation, but it's still, to be honest, reasonably accurate. It's not something you want to get involved with, and the more you can do to keep records, as Joe has said, and keep your own house in order, the less likely it will be that a claim will develop into litigation. You may have professional indemnity insurance, but even though you do, there are going to be significant calls upon you during that process. The first is time, both management time and also the time of staff that have been involved in servicing that customer. There'll be questions, there'll be statements, there'll be continuing discussions on tactics and how best to progress the litigation. Partially as a result of that, there'll also be a huge amount of stress, again, on the management. It could be an existential risk for some firms, and in particular the staff who have dealt with that customer, because their very ability to do their job is being impugned, and that really can strike home quite a lot. And then there'll be expense. You will have a self-insured amount, which will be the first chunk of any damages being paid, which may be significant. And obviously, I don't need to be telling insurance brokers that a claim, even if successfully defended, may affect your premiums going forward, in particular in the hard market that we're finding ourselves in now. Reputationally as well, litigation is not something you want to get involved in. As we'll go on to consider in a little bit more detail, the Insurance Act is relatively vague as to what is a fair presentation of risk. Do you want your firm to be on the case name of the first court decision on what is a fair presentation of risk, for example? That would be a potential problem for a number of years. And lastly, of course, we've got regulatory action. As if all that wasn't enough, you've got the possibility, if the FCA decide to take an interest in a particular instance, of fines. They have the power to release press notices giving publicity, and there's a possibility in more serious cases for suspension or prohibition of business, or indeed of an individual's ability to practice in an area, and in extremis, you might even have criminal prosecutions. We've got a question in, actually, which I'm sorry for leaping around. It's much harder when I then have to read it and then read it out to you. How public are complaints being considered judged by the Financial Ombudsman Service, bearing in mind the potential reputation fallout you touched upon? Generally speaking, Financial Ombudsman Service decisions are not published, to my knowledge. It's not like the FCA, if they've made a finding, they will publish it on their website, as would the Law Society do, or the Architects Registration Board, or any number of other regulatory organisations. However, that doesn't stop someone wanting their 15 minutes of fame, even if they've received compensation by the ordering of a monetary payment to them. It's perhaps less of a problem with a Financial Ombudsman Service decision than it would be, for example, an FCA regulatory issue or a decided court action, although the vast majority of court actions, even if they start running, end up being settled before there's actually a decision. Opportunities down the road to not become that test case, because generally speaking, there's a lot of litigation risk in a difficult question, and therefore people will buy off that litigation risk. So possible, but not, it's possible that there might be some publicity, but it's not by any means certain. Okay, I think that's back to Joe.
Yep, back to me. So I thought I did say earlier that I would look at some of these duties which were a key focus of the policy Inception stage, and I've started by saying records without realising that I would sound like a broken record when I said that out loud, so apologies. But there's sort of two main elements that I'd like to highlight in respect of records, and the first, that as an agent you're under a duty to keep and provide records of transactions entered into on behalf of the insured. So there's that duty to preserve that information. You may later be asked for it, and it's vital to have that available to the insured should they require to make a claim on the policy. The case of Young against RSA, which was heard at appeal last month, so you may have come across it, and I'll come on to address that in a minute. That case reminded us that commencement questions should be carefully considered and recorded on file. And although that's a claim against an insurer, the same principle should be taken on board by brokers as well. And the second reason that record keeping is so important is that it's an effective tool to assist in the defence of any claims that may be raised against a broker, which may not be raised for many years after the policy has come into play. Now, the onus is on the broker to demonstrate that they've discharged their duties to the client. So being able to capture that advice that you've given in writing and retaining it is really important. The lack of records, it can really impede the defence of a claim should one arise. And if there is a lack, if there's a lack of records to look back upon, then evidence falls down to what the broker's recollection of what was discussed. And we know that over the passing of time, memories fade, and therefore the recollection, it's not quite as weighty in evidential terms. And you may also come across a situation where a court has, the recollections by the insured and the recollections of the insurer, and they might actually favour the recollection of the insured, since they're not, placing insurance. It's not an everyday occurrence for them, therefore their recollection may be favoured. I've also said that you need to establish a client's needs. It's a requirement that a demands and needs test is carried out so that a broker can take reasonable steps to ensure that the contract proposed to the insured is suitable for the insured's needs, and that goes hand in hand with advising on the insurance available. You need to, ICOBS requires that a customer makes an informed decision, and therefore they must be given the appropriate information about the policy in good time and in a manner which they can understand. And that's essential to best serve the client's interest, and it involves making an assessment about the complexity of the policy and the type of customer that you're dealing with. Also includes a requirement to clarify any ambiguous instructions. If you're not sure, it's on you to take reasonable steps to show that you tried to clarify that uncertainty to ensure that the client's needs are fulfilled. You'll also want to ascertain what type of event the protection is required for, what the potential losses are. Essentially, what will the insured thinks the policy covers. There's a duty to take reasonable care in assessing the financial standing of an insurer, check that the proposed insurer is authorised to write insurance business in the UK. And I guess that all feeds, all these duties feed in as well to your fair presentation, which I touched on earlier. But in order to make a fair presentation of the risks, information must be presented to an insurer in a clear and accessible format, made in good faith. In practice, that would either be by disclosing all material circumstances which you know of or ought to know of to the insurer, or giving the insurer sufficient information that would put, you know, an insurer on notice if any further inquiries need to be made in order to reveal what those material facts and circumstances are. The 2015 Act shifted the burden of identifying what material information is to the insured. And of course, in order to meet that, the broker must have elicited all the material facts from the insured. And material is what would be deemed material as any fact or information which a prudent insurer in determining whether or not to take on the risk would have judged as material. Each case will turn on its own facts, but we know that it's not enough to rely on standard form explanations or you know, a warning that's annexed to a proposal document. More recent case law has been clarified matters and has been more favourable to the broker. Avondale exhibitions against Arthur J. Gallagher Insurance Brokers, 2018, that clarified matters, and that the broker isn't under a duty to make specific oral inquiries of their client. I'll not get into the facts of the case, but this was one where the pursuer had alleged that the defender hadn't elicited relevant information, and that the documentation that was provided to them was bulky, and that they hadn't taken account that he was, you know, allegedly not a very savvy businessman. But the pursuer failed in his case, primarily because there wasn't expert evidence led, but we don't need to go into that for today's purposes. But what was interesting is that the court had noted that it didn't consider that the information provided was bulky, but in any event, the broker had identified documents in particular which the pursuer was required to assess the accuracy of. And so cases along these lines, what they've done is taught us that data dumping on a client isn't acceptable. But on the other hand, you know, filtering the documents that's to be provided to a client is risky as well. So navigating your client to the key documentation is vital. There's a balance to be struck. But if, you know, if a broker's asked targeted questions, clearly highlighted the duty of disclosure and the significance of it and not meeting it, then it's likely that the duty has been met by the broker. And I think it's really important not to lose sight of that with increased reliance on technology and, you know, generic proposal forms. And this is particularly so in periods, well, periods of lockdown, because, well, this is a first, but, you know, when we're in a situation like this, there is less direct contact and there may be no face-to-face discussion with your client. So it is particularly important to bear these points in mind. Also worth highlighting that insured doesn't have to disclose something which the insurer's waived, whether that's by information being provided which should have prompted an insurer to ask further questions but didn't, or where the insurer asks a limiting question so the insured can infer that they don't, the insurer doesn't want to know information which falls out with the scope of that question. And the case that I'd mentioned, Young against RSA, touched on that. It's a Scottish case. It's one of the first cases, or certainly the first reported, to explore the duty of fair presentation. This is one where the broker had completed a pre-inception market presentation, and there was questions about bankruptcy and solvency, and there was a drop-down menu and the broker had put none. And the insurer had responded, there was email correspondence where the insurer had indicated that they understood that the insured had never been made bankrupt. Now, the pursuer argued that the defender had restricted its right to receive all the material information in that point, but was unsuccessful, and the insurer successfully defended the claim. The email was deemed not to be the email about understanding that the insured had never been made bankrupt was deemed not to be a limiting question. There had been no waiver there. One thing to note, though, however, is the case didn't. It was held on appeal. It was heard last month. The appeal was upheld. It didn't further explore fair presentation, so I do think we need to watch this space. And there's undoubtedly going to be further judgments on that. I should also say the duty to make fair presentation, probably stating the obvious here, but it doesn't just apply at inception. It also applies if there's any change to the risk during the policy or at renewal, which takes me very nicely on to my next slide, where I've been considering post-inception duties on a broker. If a client asks for advice to be given as to the terms of an insurance policy or a clause after it's been arranged, and as a broker you decide to give that advice, then exercise care to ensure that you provide an accurate explanation. If you're advising on a difficult or an unclear provision of the policy, any advice which you choose to give should be qualified. I would strongly suggest that the suggestion is made that the client seeks clarification from insurers or from a solicitor. Perhaps one of the most obvious continuing duties is to ensure that an insured understands their duty of notification, and for the broker to assist when claims are made. Because this can arise at a later point in time, if that duty is breached, what it means is that the period in which a claim may be brought against an insured could start running from a later point in time. And I'll not go into that in too much detail, because I know it is a point which Alistair, I know that Alistair is going to touch briefly on that, so I'll leave that there. I've also suggested that there may be mid-term adjustments. Some insurers may wish to make changes to existing policies and put policyholders on notice of the change, providing that the contract allows them to do so. And the broker there will play a key role in ensuring that the client understands the changes just the same as that they would have done at inception. Whether it's due to mid-term adjustments or some other reason, a broker becomes aware that the insured is potentially no longer insured on a particular risk, then they have to act in the insured's best interest, and they've got a duty to warn of coverage issues in that situation. And the last point, I've suggested market developments, probably particularly key at this point in time. The FCA do encourage brokers to keep abreast of market developments. It enables brokers to be able to advise their customers suitably. And this is, we're in a difficult, unknown situations here, and during periods of uncertainty like this, brokers play a key role in helping their clients understand the market, the impact of coronavirus so far as possible, because it's a new situation for all of us, and to search the market for products that meet the demands and needs of their clients. So I think that's me sort of canter through post-inception duties, and I'll pass you back over to Alistair.
Okay, thanks, Jo. Couple of questions as well, which may be good to deal with just at this point in time. One being, would you recommend that the broker obtains their client's written confirmation that they understand and have observed fair presentation obligations? In general terms, yes, if you can. So if you think about what Jo was saying about records being in place, they're really important because they give you some evidence. If it relies on oral evidence, then a court or other person or body looking to make a finding will generally prefer the oral evidence or recollection of someone that's doing this as a one-off or once a year, as opposed to someone that's doing one of these policy placements a week, let's say. If you've got a file note, that's good. That's a good start, but that's just your recollection, which may or may not be accurate. If, however, you have sent something to the customer, the client, then they've been given an opportunity to come back and say, actually, no, you didn't ask me this, or actually what I said was that instead. And if they don't come back, then either they have to say, I was too stupid to read it, or I read it, didn't agree with it, and I didn't write back to you. Even better than that is if they've come back and confirmed that that was a reasonable representation of what you've said. So if you can get it from the client, then that would be really useful. And there's another question there. Surely one of the main issues is getting enough time with the client to get their attention on all the aspects. I can completely understand that. Then all you can do to protect yourself is keep good records and explain to the client why you've been unable to examine everything in a great deal of detail. And even then, it obviously depends. If you're simply selling them a vanilla product that people understand generally and doesn't have a detailed set of warranties they're required to comply with, let's say, then it needs less attention than a complex business interruption policy, which requires a focused attention on their particular business. Moving
I
on
would
to
agree with everything you said there, Alistair. One thing might be worth suggesting is when it comes to sort of timeframes generally, that's something to be reflected in a terms of business document. It may serve to assist, and that can help manage clients' expectations in terms of timeframes for renewal and whatnot.
Okay, so claims made. I'm conscious that we're running tight to our deadline, but we have been answering questions as we were going through. Claims made. First of all, I just want to expand a little on what Joe said about the duties of a broker as you do receive claims in for the insured to make to the insurer. Bear in mind you are the agent of the insured, and unless you've set out an alternative basis, you are acting on their behalf. So it's important to have that mindset. Next, don't dabble. I would say that anywhere up to a third, maybe even more, of the claims that we deal with are people that, trying to be helpful, have just gone a wee bit beyond their expertise and have then managed to get themselves involved with something that they don't have the expertise to advise on. So if a claim comes in and there is a legal point, please seek legal advice. If it's, for example, a business interruption policy, and a key point of that is the accounting treatment of a particular thing, seek an accountant's advice. If it's a fire issue, then again, seek an expert's advice. Most people will understand if you set out reasonably that you have limits of your expertise, and if something is going to be produced to represent their interests well, then some external advice is going to be needed. Obviously, many people are aware that there's an increasing use, I think, of claims assessors to act as a mirror image of loss adjusters. Time limits. They may be in the policy. Very often it'll be forthwith, but try not to sit on that email intimating the important claim that needs to go straight back out the door to the insurers. As part of that time limits, as Joe's alluding to, you can set out how long you to hold records for in your terms of business letter. Because if you don't say anything, depending on the class of business, you can be held to have to hold the records for a very long time indeed. There was one English case where I think it was a reinsurance matter where they came back to the brokers looking for a particular piece of paper because it was that old, that a qualification had been written, and the courts held that they should have kept that piece of paper for 30 years. And you can imagine in, for example, employers' liability claims with industrial diseases, where you might have a very long tail of potential liability there. Now, if you put in your terms of business that we consider a reasonable length of time is to hold our records for 10 years, for example, it'd be difficult to come back, so long as you keep the terms of business letter you've sent out. It's easier to keep documents, obviously, these days with electronic records. But what if if you store it on the modern day equivalent of a floppy disk, and in 20 years' time, people will come and try and read it, and it's just not available. Moving on to the next slide, business interruption, which is obviously very much in the public eye just now. For policies that are already in force, one of the key questions is, well, should you have anticipated a pandemic and set that against the level of cover that is provided, and therefore whether or not a business, whether it be a little coffee shop or a manufacturer of complicated engineering pieces, be covered? I would hazard a guess that I think not, which is probably good news. It's important to remember that you're not an insurer as a broker. All you're doing is demonstrating reasonable skill and care, and that will be judged not with the benefit of hindsight, but at the time that you were providing the advice. And I, for one, didn't expect the lockdown to happen, for example, and I would imagine there'd be very few people on this webinar that would have predicted it panning out quite as it did. Hopefully, you will have systems in place to be able to provide records showing the advice you did provide. And one caveat is the duty to avoid litigation will depend on, well, how that pans out will depend on the wording of individual policies, as we've seen from the FCA's test case involving, I think it's a total of about 34 different sets of policy wording for a number of different insurers. Some of those, if you read them now, they do look a bit vague, and the question is, do they apply to widespread government action? Would a broker, when advising on the policy, when it incepted, have said, these provisions are a bit vague, we perhaps need a bit more clarity on them? Now, if there is a claim being presented in relation to business interruption, then remember what we've said. You're an agent of the insured, and if you need legal or other advice, then seek it. For new policies going forward, well, then I imagine the wider wordings that are the subject of that test case have vanished. Although you out there on the webinar will probably know about that better than I. And I imagine that if there is wording out there, then insurers will be at great pains to explain exactly what they do not cover. However, make sure that you explain all of that to your clients, to your insureds, and most importantly, keeping with the theme that Joe was ramming home, make sure you record that as you go through. And therefore, I think that leads us to the conclusions, which is the last slide before dealing with another couple of questions. The first thing is repeating it, records. They are completely crucial, not just as absolute evidence to prove one way or the other in a court, let's say, that you did explain something to your client, but what they also do is provide great ammunition for Joe and I to get rid of things before they get to that stage, because it's very difficult to provide oral evidence to a party making a complaint or pursuing a court action. It's much easier to give them a piece of paper, an email, a file note, a meeting note, something of that ilk, saying, well, clearly this was discussed and this was disclosed to your client. Fair presentation of risk, still to develop any better guidance. Indeed, I remember one of the law commissioners who was responsible for drafting the Act specifically stating that they deliberately left things a little woolly, shall we say, because they wanted to have the flexibility of courts being able to develop the law thereafter. That's all well and good until you become the broker who becomes party to a test case on what is a fair presentation of risk. as Joe said, it is something to be watched and waited for. One useful way of looking at things is, well, what would you say if you were commenting on another broker's performance in a set of circumstances? If you've got any query, would you think that they had provided enough information? Would you think that they had asked the right questions? And lastly, although this might have seemed quite scary and us being very much saying that a broker is potentially responsible for the world and its ills, you're not an insurer. You are not responsible if cover is not provided, if something is not necessarily insured. You are providing your advice to a reasonable level of reasonable skill and care, and there are instances where that means that your client, the insured, will simply not receive payment through no fault of your own whatsoever, and possibly not through their fault either. It's not a panacea. So with that, Joe, have you been keeping a note of any other questions while I've been speaking?
There is one that has come in. It's if an insurance company representative, a surveyor for instance, has visited the risk and had full access to observe and obtain information, will they be deemed to be in full access of all facts?
A typical lawyer's answer, it depends.
Yeah.
If they have, it will be much harder for them to argue that there hasn't been a fair presentation of risk, because I forget the exact wording of the Act, but it's not just what they actually know, it's what the reasonable insurer would know in the circumstances. And if the surveyor's been there and seen that it's a particular kind of cladding on the wall, for example, then they will know that there's that particular cladding, even if it's not specifically mentioned by the insured. So it does make it useful, and makes it harder for the insurer to say, no, the insured or the broker didn't tell me about everything. Here's another one. Can a broker owe duties to a third party? I'll try and answer that one. Possibly. It's much harder if they're not the direct client, if they're not the one that the terms of business letter identifies as the person who's receiving the advice. But it is possible, in particular in a commercial context, if it's, say, a group company being advised and there are different insurance policies in place for different members of that group, perhaps special purpose vehicles, etc. If it is, the law will be relatively flexible, and if it was reasonable for the third party to rely on the advice provided by the insurer, in particular if that's express, and if there's knowledge of that reliance on the part of the broker, it is possible that there could be a reliance on the advice by a third party, and therefore they could legally come after the broker. Much harder to do so if you're that third party, but it's not impossible. I'm just looking across now to see if there are any other questions. I think we've answered them pretty much all. If you do have any other questions, the slides will be circulated, and I think, yeah, there we are. You've got our details anyway. Feel free to either give us a ring. Those landline numbers do work. They come right through to my desk here and Joe's desk there, or drop us an email if that's easier. Otherwise, thank you very much for your time, and I hope you found today's webinar, if not enjoyable, at least interesting and perhaps rewarding. Thank you very much.
Thank you.